Hello, my name is Rafique Patel. I'm the Senior Partner of Bond Adams Solicitors. Today I'm going to do a short video and talk to you about disputes and litigation. Now, firstly, there are a number of different types of disputes. There are property disputes, there are contract disputes, there are debt collection matters, there are trademark disputes, there are building and construction disputes, and there are wills and inheritance disputes. The first part in any dispute is to write a letter to the other side. It is important that you set out your case, you set out who the parties are, you set out your claim, and you also annex any documents that are key to your case. The reason that this stage is very important is that court can criticize you if you fail to bring to the attention of the other side and then go on to start a court case. So that is known as the Preaction Protocol. Normally, depending on which Preaction Protocol you are following, the other side will have to acknowledge the letter within 28 days. And then within 3 months usually, they then have to respond. In that response, they equally have to set out a rebuttal of their case against your case, and they also have to annex any documents that they want to rely on, and must also comment on the documents that you have provided to them. That is known as the pre-action stage. I'm now going to talk to you about what happens when you start the court case. So the first part is you have to lodge a claim. So that claim is a claim form, and then you've got to set out the details of your case. You've got to set out key things such as dates, times, whether there was a contract or an agreement, and then you go on to set out the details of that agreement, and then you go on to set out what is known as the breach. For example, how the other party has broken the contract or the agreement. The next stage after that is the other side will file what is called a defense. They may also file a counterclaim against you. The next stage after that is called a reply stage. You have the opportunity to then put in a reply, and that essentially is called the pleading stage of the case. We now turn to the next two stages, which is the document stage and also any expert evidence. So the document stage is you have to now give to the other side, and they have to give to you all the documents that they want to rely on in the case. Now the next stage is expert evidence. There may be an expert issue. For example, if you are alleging that the machinery that was supplied to you is defective, the court may want an expert to comment on that because you are not qualified to do that. Now we're going to deal with witness statements. So the court has to listen to and look at witnesses to see whether they believe the claimant's case or the defendant's case. Now, in a contract case, for example, there may be witnesses to witness whether the machinery was working or not, also what was agreed at the outset. So the claimant will put in its witness statements, and those witnesses must come to court and they must give evidence. And equally, the defendants must also put in their witness statements. That is going to help the judge to decide. The final hearing is where all witnesses come to court, solicitors, barristers. Each witness gives evidence, and the judge is entitled to question them, and the other party is entitled to question them, which is called cross-examination. After all of that, the judge will then decide and give his or her judgment on the case, and that is how a court case goes from the start right up until the end. Thank you.